all to Vidhi Center for Legal Policy's lecture by a very special guest. In 2014, when Vidhi was just about 2 months old, we had our first public lecture on a small terrace in our office in Jangpura. And the lecturer then was Timothy Endicott, who was at that point of time the dean of the law faculty in Oxford University. And he'd spoken on the topic of arbitrariness. And at that point of time, it was a topical issue in India, and the 2G spectrum judgment had been delivered, and it was a rather and it was an interesting way to get things off to a start as far as Vidhi and public lectures are concerned. And so I'm delighted today that Timothy is back, almost 3 years to the date. As I noticed, it was March of 2014, and it's almost 3 years to the date that Timothy's back and talking about the Brexit case. And since there's so much being spoken about the Brexit case, as well as in the context of world events, as lawyers and as a legal think tank, we thought it would be interesting to get a legal perspective on the judgment of the Supreme Court in the Brexit case. But Timothy very kindly also is going to speak about the law and politics of the Brexit case. And personally, for me, it gives me immense pleasure to welcome Timothy. Not only was I privileged to be part of some of his seminars in jurisprudence at Oxford University, but throughout my time there, as in he was dean, and he was dean to many people who I see in this audience. So, in some sense, Timothy, as in I think, welcome to another home, and thanks very much for coming. And just some housekeeping, as in Timothy will be speaking for about 50 minutes, on the Brexit case, and we'll have plenty of time for Q&A after that. So, ladies and gentlemen, please join me in welcoming Timothy Endicott.
Thank you. It's really good to come home to the Vidhi Center. I'm delighted to be here. And you know, I'm especially happy to be here because I've come to India with a story of judicial creativity for you. And it feels like a privilege. I've been coming to India teaching constitutional law and constitutional theory in Indian law schools for 8 years and learning the most astonishing things about Indian constitutional law. And those I won't actually assume that you're all lawyers. Those of you who are lawyers know some of the things that are astonishing to constitutional lawyers in other countries, the creative things that Indian judges have done and are doing and will do in the future to construct a constitution for the country, a country that has a constitution, of course, but it's constantly under construction, and the Indian judges do the most creative things. Inventing a doctrine that an amendment passed through the process for amending the Constitution provided by the Constitution itself is no amendment, is unlawful, is void if it's contrary to the basic structure of the Constitution. Using that doctrine to give judges control over the appointment of judges. And then in so many cases, in the interpretation and application of rights under the Constitution, such as the 2G spectrum case that Orgo mentioned, using a guarantee of equality to create a doctrine of arbitrariness that the judges can use to overturn a government policy decision on the ground that a different policy would be better for the country. And of course, there are the famous cases about the use of the right to life in the Constitution to regulate pollution. These astonishing things to lawyers in other countries, these astonishingly creative things that Indian judges do are famous. And yet I have a theory that in every, I'll be very, I'm a cautious person, I'll be very cautious and limit my grand theory to common law systems. I wouldn't be surprised if you could extend it to systems of law in general. And my grand theory is that in common law systems, in each of them, in different ways, you will find judges doing things, creative things in the construction of the Constitution that will surprise you, even if you're Indian. Of course, the Americans do creative things, and I'm Canadian, and our Canadian Supreme Court does astonishing things. And I'm privileged to have a story of judicial creativity in the construction of the British Constitution. And it's an important part of the story that this, of course, is not the first instance, but what an extravagant and flamboyant instance of judicial invention of the Constitution. And when I say that, but throughout my talk as well, you will discover that I'm going to be saying something controversial. To give you a heads up, to foreshadow what I'm going to do, I'm going to totally disagree with the reasons presented by 8 of the 11 UK Supreme Court judges. 11, that's all of them. There's a vacancy, that's all of them. They have never sat in the same case before. This is the constitutional case of the century that I'm going to tell you about. And a powerful, large majority of them, 8 out of 11, decided that Theresa May, contrary to her plans and her intention, could not begin the process of withdrawing the United Kingdom from the European Union without an act of Parliament. And I'm going to say that there is no legal basis for that. That's the law today because of a rule that the judges invented in the Miller case. There's something controversial, and I'll try to defend it. I just thought I'd give you a picture of the European Union just to show you what we're talking about. It's incredible. It's worth remembering how extraordinary this outfit is, the European Union. And you see the colors there, how the colors move east as the years go on. Well, they moved west as well, of course. Britain didn't join until 1973. But this has become a union of all of Western Europe, and it is challenging the border between Western and Eastern Europe, moving the border of the European Union into what's indisputably Eastern Europe. There are neutral countries, as they think of themselves, like Switzerland, that aren't in the European Union, Norway. And there are difficulties in the Balkan states, the fallout of the breakup of Yugoslavia. But it's basically all of Europe, and it's moving into the East and creating challenges in dealing with Russia. And this expansion of the European Union is part of the background to what we're talking about. The country which has the most nationals resident in the United Kingdom is not India. The foreign country is not India, it's Poland. Over 800,000 Poles in the United Kingdom. Extraordinary change in the demography of Europe since Poland joined in 2004. And there's a little vignette of some of the tensions behind the British plan to leave the European Union. It's partly migration. It's partly a sense of a desire for independence. It's a lot of incoherent results of a very tendentious and controversial campain in a referendum. Here's the European Union, started in 1950 as a free trade community for coal and steel, and they did something similar with atomic energy. Landmark Treaty of Rome in 1957, creating the European Economic Community, a general free trade zone. And Britain joined that under Harold Wilson, Labour Prime Minister, in 1973. And it was always designed by the designers of the European Economic Community to move towards ever closer union and to create genuine free trade, free movement of goods and services and of people among all the countries of the European community. And the move, the symbolic move towards not just a free trade community, but we don't know what else, political union, controversial with some people resisting it and some people wanting a super state. The movement towards some sort of undefined and controversial political union was signified by the name European Union in the Maastricht Treaty in 1993. They created a currency, and you'll know how challenging that step has been, and how you can imagine how pleased the British have been that they're not part of it. In the 2009, rather a turning point in the European Union, there was an initiative by the centralizers to create a constitution for the European Union, and it failed. In the course of trying to create a constitution for the European Union, which I think was shot down for symbolic reasons by Eurosceptics. And in the course of trying to create a constitution, they invented a provision for withdrawal from the European Union. And although and when the Constitution initiative failed, they made the Lisbon Treaty of 2007, which came into effect in 2009. And it included that provision for withdrawal called Article 50. And today it's more diverse than India. Extraordinarily diverse community of nations. A community of nations and yet a legal order. Extraordinary, unprecedented in human political history. With a huge population, nearly half the population of India. And here's Article 50. Article 50 says that a member state can pull out. They wanted to make further integration, closer union, palatable by putting right on the table that a member state, they remain states with sovereign power to withdraw from this treaty organization that's more than just a treaty organization. And if they decide to do so, they must notify the European Council, and then from the day of notification, there's a 2-year period for negotiation, and at the end of that 2-year period, the member state that it has signified its intention to withdraw will no longer be a member state of the European Union. If they haven't cut a deal with the European Union over trade and fisheries and agriculture and migration of persons, by then they will be, the member state that proposes to withdraw will be in a difficult position. I think this is constructed to put the European Union in a strong bargaining position over relations with a member state that withdraws. But of course, whatever this, if there were no procedure so that a member state needed a new treaty to withdraw, the European Union would still be in a strong bargaining position over trade relations with a state like Britain that's planning to withdraw. Why are they planning to withdraw? Well, because of the most stupendous tactical mistake by Prime Minister David Cameron, I think you could say. He, as leader of the Conservative Party and as Prime Minister, he proposed to hold a referendum on in or out, leave or remain, on European Union membership for the UK. And he proposed it, I think, because, and I think it's nothing unfair that I'm saying about David Cameron, he proposed it because of tension between Europhiles and Eurosceptics in his party, as a response to some pretty serious hostility to the European Union in his party. He proposed a referendum in which I think he expected that the British people would vote to remain. They voted 52% to leave. And I just thought I'd put up the statistics. It's kind of important. The one about Scotland, 62% voted to remain. And now Nicola Sturgeon, the leader of the Scottish National Party, is using Scotland's huge vote in favour of remaining as a starting point for seeking to talk her country people in Scotland and talking the United Kingdom into agreeing to a new referendum on independence for Scotland. Likewise, Northern Ireland. Do you know, by the way, I'll put my cards on the table. I think that Brexit is a big mistake. I think that the British, if there's anything like a union of nations on that continent, it may be, I wouldn't pass judgment on Switzerland, and maybe there's good reason for them not to be part of it. But given my sense of the role of the British nation in that continent, I think the British ought to be involved in making a European Union, if there's a European Union, making it work well. And incidentally, I think that an international organization that achieves genuine free trade is an impressive accomplishment. And I don't think it was moving towards the sort of superstate that would have damaged the British nation. So I thought that Brexit was a big mistake. And it's not that I think it's crazy to vote for Brexit, because there are values for Britain. There's value for Britain in attaining responsibility and authority over the areas of the life of their nation that are currently ruled by European Union law. They will have to take responsibility for labor market regulation, whereas today Tory politicians can blame it on Europe. they will need to take responsibility. There is some value in the independence that the British are going to going to gain. So I don't think it's not. I have friends who think that Brexit is just crazy. I don't think it's crazy. I think it's a mistake. And if I had been minded to vote in favor of Brexit on grounds of attaining greater independence, I would have stopped because of Scotland and Northern Ireland. I think that what has happened and what's going to happen poses a real risk to the Union, to the United Kingdom. And I've just thought I'd put my city, Oxford, 70% voted to remain in the European Union. You can imagine sentiment in a university like Oxford about this anti-international initiative. The Prime Minister resigned the next day. Theresa May, in an election, a very interesting leadership campaign within the Conservative Party, became head of the Conservative Party and then, of course, was appointed by the Queen as her Prime Minister. And Theresa May announced that she was going to give notice to the European Union that Britain intends to withdraw from the European Union. And this is what she ran into. Gina Miller. Gina Miller, the claimant in the case that I'm going to tell you about, brought proceedings in judicial review for a declaration that Theresa May had no authority to commence Brexit, to trigger Article 50, to signify the United Kingdom's intention to withdraw from the European Union under the exercise of prerogative power. And she asked the judges to hold that such a move could only be authorized by an act of Parliament. You might think that her motivation was anti-Brexit. I don't know her views on Brexit, but her motivation was actually, and I've heard her talk about this, was actually a motivation concerned with accountability and transparency and responsibility in government. She is a financial analyst and advisor, has a finance company with her husband, and they have been campaigners for accountability and transparency in pensions and in other investment mechanisms. And she has a burning commitment to promoting accountability in government. And that's why she went to court to ask the court to tell the Prime Minister that she could not use a power that Gina Miller described on the radio as this ancient, secretive royal prerogative. She wanted it debated in Parliament. She's going to win her case, as you'll discover when I tell you about what the judges decided. She won, and it was kind of a surprise to a lot of people. At first instance in the High Court, three senior judges, decided on the 3rd of November that she was right, that Theresa May can't use prerogative power to trigger Article 50. She needs a statute. The government appealed, and look how quickly they decided it. I forget when she began the proceedings, but they decided it pretty quickly, and then the Supreme Court got its act together and heard the appeal just a month later, almost exactly a month later, and they issued their decision in January. All 11 judges with a parade of 58 barristers for an array of different parties and for the government. Extraordinary pageant of forensics and advocacy in the United Kingdom Supreme Court. And they, by a majority of 8-3, 3 dissenters, upheld the High Court decision. And that's the end of the line legally, the United Kingdom Supreme Court. And so then Theresa May knew that she had to ask Parliament for approval. The Conservative Party the Prime Minister presented a bill to Parliament, the European Union Notification of Withdrawal Bill. That's a misnomer. It's not notification of withdrawal. It's notification of the United Kingdom's intention to withdraw. It's not a typo. It's a mistake in the title of the act. That passed through the House of Commons. The House of Lords amended it. The House of Lords amended it to require her to get another approval from Parliament at the end of the negotiation process, and amended it to require that she guarantee the rights of people from other European Union states who are resident in the United Kingdom. It goes back to the House of Commons, and they strike out those amendments and pass it again, and this time the House of Lords could have insisted and created a sort of political crisis, and they didn't. And it went through last Thursday, and Theresa May announced today that she's going to trigger Article 50 Wednesday of next week. So 29th of March 2019, Britain will stop being a member state of the European Union if they haven't negotiated something between now and then. That's where we're at with Brexit. Here is the Divisional Court's reasons. The lawyers for Gina Miller put it very simply. People in the United Kingdom have rights under European Union law. Harold Wilson took the United Kingdom into the European community, as it was called then, in 1972, by agreeing to a treaty. The treaty would not have effect just because the Prime Minister agreed to it. Treaties in Britain, they have what lawyers call a dualist system of international and domestic law. The Prime Minister, under prerogative power, can make treaties and terminate treaties, but the Prime Minister can't change the law. And if a treaty will only work if changes are made to British law, then the Prime Minister needs to ask Parliament to change British law. That's what they did in 1972. Harold Wilson goes to Europe and negotiates British entry into the European community. He signs the treaty, but it's not ratified yet. If he ratified it, Britain would become a member state and would be in violation of all its obligations. So he signs the treaty and says to his European partners, hold on, I'll be right back. I've got to go and ask Parliament to change the law. They present a bill to Parliament. Becomes the European Communities Act 1972. And it says, rights and liabilities arising under the treaties shall have effect in UK law. And Parliament passes that, and Harold Wilson says, oh good. And he goes back and ratifies the treaty. And Britain becomes a member state not by act of Parliament. Parliament can't change international law. Britain becomes a member state of the European community by exercise of the royal prerogative by Harold Wilson. Now, the Divisional Court accepted the following argument from the lawyers for Gina Miller. Today, 2017, just as ever since 1973, people in the UK have rights under European Union law. They have rights under European Union law because of the effect of the European Communities Act 1972. Parliament gave those rights to people, and the government cannot take away rights that have been conferred by Parliament. And as you'll see from this quotation, they accepted that. And they based it, they had authority for it. The wonderful case of proclamations in 1611. The Crown cannot change domestic law and nullify rights unless Parliament confers the power to do so. Here's the case of proclamations. One of the great steps in the separation of powers in the United Kingdom Constitution. King James couldn't get the tax revenue that he wanted from Parliament. Parliament wouldn't agree to levy the tax enough revenue for his military. King James comes up with a great money-making scheme. He creates a new planning system for London. He proclaims that no one can build a building in London without permission, and he'll give permission if you pay a big fee. It was urban planning with a revenue purpose. And people complain about this and go to court, and here's Sir Edward Coke, very gutsy judge, standing up to King James and saying, you can't do that. You have no lawful authority to change common law or statute or the customs of the realm by proclamation. Simple as that. Owner of property cannot be prohibited at common law from building a building. And if you prohibit them from building a building and say you'll have to pay a fee, you've done something, you've purported to do something that only Parliament can do. So the proclamations were of no effect. Now here is what I call a fallacy. Some of you will disagree with me. The three distinguished judges in the Divisional Court, that's the first hearing in the High Court, would disagree with me. I think it's a fallacy to say that the case of proclamations supports Gina Miller's case. And the reason it's a fallacy is that if she had triggered Article 50 by exercise of the prerogative, Theresa May would not have been changing any part of the common law or statute law. The true rule of the British Constitution is not that the government may not take a move in international law in terminating a treaty or signing a treaty if it will change people's legal rights in the UK. The true rule is that she cannot act against statute or against the common law. And she wouldn't be acting against the statute, the 1972 European Communities Act. If you terminate the treaty, then there will be nothing for the European Communities Act 1972 to give effect to. And that doesn't mean that you're acting against the statute if you terminate British membership in the European Union. I'm going to explain this further when we get to the Supreme Court decisions. The Supreme Court, to give them credit, was not persuaded by the same fallacy. They did not treat the case of proclamations as authority for their decision that Theresa May could not take Britain out of the European community by exercise of prerogative power. This is what they did instead. It would be inconsistent with long-standing and fundamental principle for such a far-reaching change to UK constitutional arrangements to be brought about by ministerial decision or ministerial action alone. We cannot accept that a major change to UK constitutional arrangements can be achieved by ministers alone. That's a typo. It's their typo, not mine. By a minister alone. It must be effected in the only way that the UK Constitution recognizes, namely by parliamentary legislation. This conclusion appears to us to follow from the ordinary application of basic concepts of constitutional law to the present issue. There, I've spent the time reading it out because this, in my opinion, is it. That is, if there is a justification for the decision of the Supreme Court, that is it. And I have to say that when they talk about fundamental principle, when they talk about basic concepts of constitutional law, the reason they say fundamental principle and the reason they say basic concepts of constitutional law is that there is no legal authority for the proposition. The proposition is that, to paraphrase these crucial parts of the majority decision, the proposition is that if the termination of a treaty will have a major effect on UK constitutional arrangements, then it cannot be done in the exercise of the prerogative over treaties. It needs a statute. And there is no authority for that proposition. They give none, and there is none. I hasten to emphasize that this doesn't mean that they did the wrong thing. If we go back, let's go back to 1611. I'm not a 17th century lawyer. Any of us could study the law before Sir Edward Coke said this. If we did, I don't know that we would find any authority for this proposition. I wonder to what extent Sir Edward Coke was innovating. And it may be that that if we did look at the law, here's my guess, we'd find something quite complex. He does refer in the case to authorities like John Fortescue, to scholars. And if we actually looked at the cases before 1611, I think we would find a lot of complex stuff that lawyers would go to town on that would not directly and clearly support his proposition that the king cannot change the common law or statute by act of prerogative. And you know what? That doesn't mean that he did the wrong thing. It may be a great move forward in the British Constitution to detach the tax-raising power from the executive. Of course, this was successful as a matter of common law. It was not successful as a matter of British politics. And the Stuart King's refusal to go along with what you see on the screen was a major driver towards the Civil War. Catastrophic civil war in the 1640s. And when they pull themselves together, restore the monarchy, and get rid of the Stuart kings and invite William and Mary to come and be constitutional monarchs rather than authoritarian monarchs, they solve this in the Glorious Revolution, 1689, and they write in the Bill of Rights, and the king has to agree to it as a statute, that only Parliament can raise taxes. It took it. This changed the common law. It didn't change British practice. It took a revolution and Parliament to solve this problem. But I think this was a brilliant innovation if it was an innovation. So I'm not saying that the Supreme Court of the United Kingdom did the wrong thing by doing something for which there was no legal authority. And there are two ways you might look at this if you feel that they did the right thing giving it to Parliament. One is you might say, well, surely it is, if there's no case that's decided it before, surely it is sort of instinct in the Constitution that a major constitutional change needs parliamentary approval. Or another way you might look at it, you might say, no, there's no source of constitutional law supporting this decision, but it was a great change, and the judges engaged in a stateswomanlike, in the case of Baroness Hale, change in the Constitution. So I'm not saying it's wrong just because it's a remarkable innovation. Now, I want to very briefly introduce you to Lord Reid, just to show you that I'm not the only person in the world who thinks this. And Lord Reid's judgment, he's one of three dissenters, the others are Lord Carnwath and Lord Hughes. He's the leader of the dissenters. And he puts right on the table, and citing another important case that the majority also talk about, the proposition that the government cannot change the common law or the statute law, the law administered by the courts of law, by act of prerogative. And then he, in this crucial paragraph of his judgment, he says that doesn't mean that Parliament must enact an act of Parliament before the UK can leave. The effect that Parliament gave to EU law is conditional on the application of the EU treaties, conditional on the UK's membership of the EU. And when Parliament said that the UK's membership in the European Union shall have effect in UK law, Parliament did nothing to take away the power that the majority admits they have to terminate a treaty. And by the way, this is the crux of his judgment. It's preceded by a meticulous, impressive account of the 1972 statute and an explanation of what Parliament was doing in that statute and why Parliament's act is best interpreted as giving effect to rights that arise from the international agreement and not as either making the international agreement or prohibiting a change in the international agreement. So I think Lord Reid's speech is quite impressive and simply conclusive, and that's why I think it's the case that you have to understand the Supreme Court majority as innovating. Now, I want to use this really interesting point in the majority reasons as a starting off point for asking the broader question of principle as to whether it is a better thing for the British Constitution to require Parliament to authorize a change to a constitutionally significant treaty. They're just sort of warming up, they're setting the background, and they say, this is the majority of the Supreme Court. Sovereign originally, right there, they don't say when, I would say even before 1066 when the Normans invaded, sovereignty was concentrated in the Crown, subject to limitations. I think that's so true, and it's something that people forget. The British, they never had an absolute monarch. When the Stuarts tried to be absolute monarchs, that led to civil war. Since William the Conqueror, he was not an absolute monarch. He claimed to be taking English kingship as of right in a royal tradition of kingship that extended back hundreds of years, no one knows how far, before Edward the Confessor, before King Canute, a tradition of limitations that included a responsibility to govern cooperatively with the powerful men of England, the barons, and a duty to abide by the law. Those were the limitations. They were ill-defined, and the country didn't have effective enforcement mechanisms for the king's duties. And so the crown was exercising all of the powers, judicial, legislative, and executive, but with everyone understanding that it was not unlimited power. The problem was there was no separation of powers to enable to create mechanisms for holding the king to his obligations. However, say the judges, over the centuries, those prerogative powers, collectively known as the royal prerogative, were progressively reduced as parliamentary democracy and the rule of law developed. Parliamentary democracy, that's taking the legislative power away from the king. This happened very early, by 1295, taking the legislative power from the king and requiring him to exercise his legislative power in Parliament, which effectively transferred legislative power to an assembly, to a bicameral assembly of the landed gentry and the rich merchants. Not very democratic when it's the landed gentry and the rich merchants. It didn't become democratic really until the 20th century, but already representative of property and interests in the country. That's parliamentary democracy, as they call it today, and the rule of law. Separation of the judicial role from the king himself, the king personally, which developed as the common law courts became a whole system which the king wasn't controlling. He was controlling it in the 1100s, but long before Sir Edward Coke, he wasn't controlling it. And then there came a crisis, another Sir Edward Coke judgment where the king wanted to decide cases personally and Sir Edward Coke told him he couldn't. Separation of judicial power from the king personally. Even then it wasn't really effective until they banned, by statute in 1700, banned the king from sacking judges. So these are the two developments. You take away judicial power from the king, and you take away legislative power from the king. And they needed to do that to achieve constitutional government in the UK. And you in India have found your own unique way of building on the heritage of those separations of legislative from executive and of judicial from executive. Now, I want to point, sorry, here, before I tell you about Magna Carta, I want to point something out about this process of taking power away from the king. They call it progressively reduced. And here's my main sort of proposition about constitutional practice in the United Kingdom. This approach to constitutionalism has been negative, subtractive. They have over centuries, over 1,000 years, taken power away from the king without ever working out what the executive power ought to be. And they often talk as if, and the advocates talk, the barristers talk in the Miller litigation as if there is something wrong with executive power per se. As if the improvement in constitutionalism in 1,000 years in the United Kingdom has been a movement in the direction of taking executive power away and giving it to other people, which is admittedly not complete. By absent-mindedness, the English, the British somehow haven't managed to take away all power from the executive, as if constitutional progress equals diminution of executive power. And my main point is that this is a fundamental constitutional mistake. No one, Dr. Ambedkar, take a genius and say, construct a constitution for a country. I don't care if it's India or New Zealand or Japan. No one could do the job that Dr. Ambedkar set out to do by saying, oh, executive power, that's bad. You have to say more than that. There's something, I'd even be willing to admit that executive power is generally dangerous. And still, and still you need it. And so good constitution making requires, number one, that the executive can't legislate as it sees fit. Number two, that the executive can't decide lawsuits. It needs those things. Those are separations of power from the executive that are constitutionally, I think it's a pretty general principle of political community, actually. I don't know if it's an absolute principle, but it's a pretty general principle that there's a value in separating judicial power from the executive and separating legislative power from the executive. But it would be a mistake to think that the executive should have no power. That would be a recipe for a disastrous constitution. So what I'm proposing is that along with the principles of parliamentary democracy and the rule of law, they have in Britain, and they ought to recognize, and they ought to articulate, and they ought to explain a third principle. And the third principle you might call effective and accountable executive government. They've got it. They just don't realize it, and they don't talk about it. They didn't talk about it in Magna Carta. Magna Carta, if you want my view, it was just a peace treaty in a tax revolt. A peace treaty and a tax revolt that failed 6 weeks later when the king got away and started a civil war again. So it's a failed peace treaty. And in the peace treaty, what the barons did was they listed all the things the king was not supposed to do and got him to agree not to do those things. Not to do. Not to allow people to build fish weirs across the Thames. He was doing that, King John, very bad king. He was letting people pay him money for the right to build a weir across the river, and then the barons couldn't sail their barges up and down the river. It's part of what led to this tax revolt. And he was doing much more consequential things to do with his control over inheritance and succession of property and the marriage of a widow. He was abusing his position to get revenue, and they didn't write a constitution. They wrote a list of things he mustn't do. That's part of, you might say, the very beginning of the negative approach to executive power. You will not find, I promise, read it, you will not find in the 1215 charter that they agreed to at Runnymede, or any of the successive Magna Cartas that later kings adopted, you will not find a statement of what the king can do. No account of it. The first great English constitutional theorist, John Fortescue, when his side was losing in the 100 Years' War, he ended up in exile in France. That gave him time to write a beautiful treatise on the theory of the English Constitution. Read it. I think I'm right to say that you will not find an account of what the king can do. You'll find an account of what he mustn't do, and it's already, and this is why Sir Edward Coke cites it in the case of proclamations. He's already saying in the 1460s that the English kingship is not what he calls regal kingship, it's political kingship. And by political kingship, that was Fortescue's special phrase for kingship in which the king cannot raise taxes as he chooses, but can only do so politically, by which Fortescue meant in Parliament. So the king mustn't do that, and Fortescue didn't say what the king was there for, what he could do. Sir Edward Coke, read the case of proclamations. Read the brilliant case where he told the king, you can't judge lawsuits personally. You have to delegate it to your judges. In these cases, and in all his work, Sir Edward Coke made brilliant moves to tell the king what he couldn't do, and he never said what the king's authority is. He would not have presumed. It would have been presumptuous for him to tell the king, oh, here's what you can do, Your Majesty. Never did. Never. And for his purposes, he didn't need to. In those two crucial steps that he took in the development of the separation of legislative power from the king and the separation of judicial power from the king, he didn't need a theory, an account, or he didn't need to say anything at all about what the king could do. John Locke. John Locke, I propose, from my experience, and I hope somebody will tell me if they have better instances to provide. As far as I know, John Locke is the person in the British tradition of political and constitutional thought who did the most to articulate what the executive power ought to be, and it's fragmentary and inadequate. Brilliant, don't get me wrong, a brilliant thinker, and he doesn't give any satisfactory account of the executive power. Here is the executive, he talks about legislative power and judicial power, we've all heard of that, and executive power. Here's a brilliant philosopher who actually thought about the power words have over our imaginations. And he got misled, I think, by the word executive, and makes a mistake that some of my students make of thinking that the executive power is the power to execute the laws made by Parliament. That's a huge mistake, huge mistake. He says it's necessary that there should be a power always in being. That's a brilliant little insight, brilliant philosophical insight. The legislature can have terms and they can have a vacation. The judges have terms and vacations. Of course, you have to be able to find a judge in the middle of the night to get habeas corpus. That's a sort of special detail. But the executive has no terms, has no vacations, 24/7, 365. You need a power always in being to see to the execution of the laws that are made and remain in force. Now, this is an incoherent account of executive power if by executive power we mean that the power that the executive branch of government ought to have, and a totally inadequate account of the executive power of the British government in his day or in our day, because the British government does not simply execute the laws made by Parliament. The British government is, like the Indian government, runs the departments of state and is equipped and has constitutional privileges in developing policy and proposing policy initiatives to the legislature. It's a much more proactive role than the role of executing the laws, but of course, it does include the job of executing the laws. Absolutely. This is a fragment of the role of the executive. Now, let me show you another very important fragment. He comes up with a special word for it which hasn't stuck. This is the power that's at stake in the Miller case. He calls it federative. In addition to legislative, judicial, and executive, he's got a fourth branch of government, but there's a funny part in Locke where he says, of course, if you've got a federative branch and an executive branch, they could end up at odds with each other, so it might be a good idea for the same people to exercise the executive and the federative power. Well, there's a insight from the Department of the Blindingly Obvious. It would be a pretty dangerous constitution where there's a different branch that executes the laws and another branch that does this stuff. But this is beautiful. Look what he says. You need people on behalf of a political community, given the nature of this planet, nature of the multitude of nation states and the need of our nation state, any nation state, to deal justly and in the public interest and cooperatively with other states, to deal justly and in the public interest with persons from outside our state, and of course today with so many organizations that John Locke didn't have to think about, like the United Nations, European Union, WTO, and so on. You need this. You need people acting on behalf of the community to exercise the power of war and peace, as he calls it, to be involved with foreigners. This power is much less capable to be directed by antecedent standing positive laws than the executive, which, remember, he made the silly mistake of thinking is the power to execute the laws. What is to be done in reference to foreigners? What a lovely phrase. What is to be done in reference to foreigners? A very important challenge, and it depends on them, and they get up to all kinds of things. Their designs and interests vary, and so you, India, Britain, Switzerland, needs people of prudence and needs to leave it in great part to them to manage to the best of their skill for the advantage of the Commonwealth relations with other people. Now, I think this is a very important perception And again, it's a fragment of an incomplete picture of the executive. Because if we just think for a moment of the role of the executive government in a good constitution domestically, you know, it's not just in regard to foreigners that um, designs and interests vary. In internal affairs, in India, and India is the paradigm example, but in every country, in internal affairs, the executive needs to respond to the variation of interests and designs of people in our community and develop policy in the public interest. So we need an executive that has, similarly domestically as internationally, has this capacity to act in the common interest. Now, Locke, that's the highlight, that's the high point of constitutional thinking about the executive. I haven't found anything better, but maybe someone will point something out in the discussion. William Blackstone, in his lectures, the first professor to be hired to teach English law in my university in Oxford, gave these lectures that become his commentaries on the law of England, and he emphasizes the need for an executive with unanimity and strength and dispatch. He kind of glorifies the king and talks about the mysticalness of the king, and he reckoned it was important for Britain to have a king that everybody was slightly in awe of. And I think that's a bit silly. But this is true. This is true. You need an executive with unanimity and strength and dispatch. This, too, is so radically incomplete a picture of the executive because, of course, he doesn't have the room in his commentaries to explain what functions it is that require unanimity and strength and dispatch. He lists examples of prerogative power, but he doesn't give an explanation of where you need this. But what I propose to you is that Brexit is a prize example. The House of Commons cannot negotiate with the European Union. Theresa May can. Now, that's only the beginning of an argument that there isn't actually a constitutional problem to be solved if Theresa May proposes to trigger Article 50 by an executive act. You need more. You need one more crucial development in the British Constitution that you've benefited from in your Constitution, that Canada has borrowed very gratefully from the British Constitution. And that is making the executive accountable to the House of Commons, the Westminster system of accountability of the executive to the legislature. You need that, and they've got it. They've got an executive that's accountable to the legislature. And of course, don't forget, that is itself democratic. Theresa May is not King James. She's not an arbitrary hereditary monarch who needs to be constrained. She is a democratically appointed politician who needs to be constrained. She needs to be held to account, and they need in Britain a system in which the House of Commons can throw her out, they've got it. In which the House of Commons can ask her questions and she has to answer, they've got it. So, there you go. I'm going to stop with this slightly open-ended suggestion that there wasn't actually a problem to be solved by the constitutional innovation of the majority of the Supreme Court. But you may, like so many of my colleagues, be much in sympathy with the direction of their thinking, which is simply that in our Constitution, they reckoned, surely it's for Parliament to do something so important. That's the rationale for the Miller case. I've in danger of talking for too long, so I'll stop. And I haven't fully got into the politics of it, which I promised Orgo I would. So I hope I'll have a chance to tell you more about how things are playing out and how they're likely to go in Britain in the questions. But I will stop there and invite any questions that people have.
Thanks very much, Timothy. As in, that was a real tour de force on English constitutional history, as in not just about the Miller case, but using the Miller case as a starting point. I think maybe One question that sort of I had to perhaps kickstart this, which is not directly on English constitutional history, but more on constitutional theory and separation of powers. Uh, it struck me while reading the Federalist Papers as a precursor to the American Constitution that what they were really worried about was not executive power running amok, but legislative power. Essentially, which is why they wanted to separate as in the House, as in the Congress, into the Senate and the House of Representatives. They wanted a directly elected president. Some would say that they wanted an independent judiciary. And it all seemed to be because they wanted to control legislative power. So it seems that the starting point of, as in the American Constitution, a lot of Constituent Assembly debates in India also see the primary threat to separation of power being overarching legislative power. Now, you've articulated the constitutional history of the UK as sort of trying to move away from some ill-defined mass of executive power that the king wielded and sort of so slowly chipping away at that, and to get to what separation of powers is in the UK. So my question really is, and it's sort of poorly articulated because I'm still thinking as I'm speaking, but the question really is that how much is it about different starting points in different constitutional cultures that you want to, as in curtail legislative power, as in India and in the US, as your starting point, you don't want popularly elected legislatures to become akin to mobs. Whereas in the UK, as in it seems that the starting point, and perhaps maybe a bit of clairvoyance here, that the starting point was to limit executive power.
Yes, isn't it? Aren't they fascinating, the British? That they've never. Well, I'm generalizing a bit, but if I were to generalize, I would say they have never collectively seen the danger that the Americans and the Indians and the Canadians and other constitution framers have seen in legally unlimited legislative power. And they've been happy with that since the Glorious Revolution. They're more or less happy with it now, although of course, I have a lot of colleagues in Oxford and in Britain, human rights lawyers who think that parliamentary sovereignty is dangerous, that the European Convention on Human Rights is a huge improvement in governance because of the ways in which, although not interfering with the legal sovereignty of Parliament, it sort of puts Britain into a position where it has to go along with decisions of judges in the European Court of Human Rights in Strasbourg. And those people aren't great fans of parliamentary sovereignty, except when it comes to the Miller case. And they all think that, oh, they're all standing up for parliamentary sovereignty now. So how about this? Even the human rights lawyers in Britain who are not wholesale in favor of unlimited legislative power, they'd prefer that over executive power.
Well, I think we are very familiar with sort of constitutional lawyers and other advocates as in molding their arguments depending on the ends that are to be achieved. And I think you do see a lot of that in India, and especially with our activist courts, as I think a lot of people who might otherwise have been fairly happy with conservative courts often like activist courts because we like the results that ensue. But I think that there will be. I have many more questions, but in the interests of time, I think there will be a few questions. Maybe we'll collect a few questions, both on the case itself and the part that Timothy couldn't get through, as in which is the politics, because I think we're right in the middle of that. The case may have ended, but the politics is only perhaps beginning. And so we'll take a few questions on that. Yeah, we'll take one there.
Can I just say that you said that UK triggering Article 50 is not a constitutional matter because statute law, English common law will continue and the Supreme Court misunderstood. But there is a very serious constitutional matter involved because Scotland is now going to have a referendum and they want to become independent. And similarly, Northern Ireland, with the Good Friday Agreement, there's an open border between the Republic and Northern Ireland. And if Northern Ireland also leaves the EU, then I don't think you can have an open border. So those are major constitutional matters.
We will collect a few. And will that be okay? There's a question here.
Yeah, as we know that in United Kingdom there is a parliament sovereignty, and basically the Honorable UK Supreme Court is to interpret, not to legislate, if I'm not wrong. So, and if the UK Parliament has passed a particular law, which is not in contravention of Human Rights Pact, which was signed in 1882, if I'm not wrong. Unless the law which is made by UK Parliament is in contravention with the laws of human rights Pact, which was signed in 1982, the Honorable UK Parliament doesn't have the power to negate that law, which will be passed by a Parliament of the UK. So what would be the solution of what would be the solution to stop the Parliament in regard to this Brexit?
Thank you for the talk, Professor Endicott. I just have one small question on the political aspects. In the aftermath of the case, I actually read some reports how a lot of the Labour MPs are also, in their opinion, favouring the exit, and the formality of introducing this bill in the Parliament, getting its passage is more like just for talking purposes, but there's no real opposition, given that the majority of the population has supported it. So I just thought if you could probably give some insights on that aspect of the case as well and the aftermath of it.
We take these three.
Sure.
And
Okay,
the politics.
good. Yes, the first question, I completely agree that any impulse or driver towards Scottish independence and any driver towards further trouble in Northern Ireland is of major constitutional importance to the United Kingdom. Yeah, I agree. Now, and that's the influence on Scottish politics. And these are very different situations. Scotland, what you've got is a tremendously well-organized nationalist party seeking independence with quite a lot of support, but not enough to win the referendum 2 years ago. And that's a genuine danger to the United Kingdom. The impetus that Brexit gives in favor of Scottish independence. But I don't think we can predict that it's going to destroy the United Kingdom because of the predicament Scotland faces. If Britain leaves the EU and then Scotland leaves the United Kingdom, they will have real trouble getting back into the European Union, and they might have to accept the euro as their currency. And those are politically countervailing forces, and I don't know how the politics of Scottish independence will work out in that context. But Brexit doesn't help. And as for Ireland, good grief, a border between the European Union and not the European Union across that island is just a dangerous political prospect, and I don't know how things are going to work out there. Now, the second question, I didn't know what the 1982
It was a Human Rights Pact signed by United Kingdom.
Oh, do you mean the Human Rights Act? Yeah, 1998. The British Parliament passes the Human Rights Act. And I have colleagues who write books describing it as incorporating into UK law the European Convention on Human Rights. It doesn't incorporate it. It gives certain kinds of legal effect to it, but not a legal effect that overrides parliamentary legislation. Remarkable provision that judges can declare that a statute is incompatible with the rights in the European Convention, and they've done it a couple of dozen times. But when the judges declare that a statute is incompatible with the rights in the European Convention on Human Rights, that doesn't invalidate the statute. You can't because of parliamentary sovereignty. That does trigger, by the Human Rights Act, a power to amend the incompatible legislation through a fast-track procedure. Now, that doesn't change the constitutional position. First of all, Parliament could repeal that act any time, and Theresa May, when she was Home Secretary, wanted to repeal it. And secondly, as long as the act is in place, it gives Parliament control over amendments to legislation that is incompatible with the rights. The third question,
Yes, the Labour Party didn't oppose the government when Theresa May proposed the legislation to authorise Brexit, and that reflects the dramatic political effect of the referendum. Only 52% of the British electorate voted in favour of Brexit. And when David Cameron thought up this idea, and he campaigned very vigorously, very powerfully actually, in favour of remaining in the EU. And he thought he was going to win it. And when he came up with the proposal for the referendum, I think a lot of people wish he had put a weighted majority into it so that it would take 60% or even 53% to leave the European Union. And he didn't, for political reasons, because he wanted to show that he had done everything for the Eurosceptics to have their opportunity and that the nation had decided. Well, it went the wrong way, and I think it's I think, by the way, that it's a mistake for any government to put a referendum to the people on a proposal that the government is not asking the people to adopt. I think it's a big mistake, and then to do it without a weighted majority is a further mistake. And then so you do a 50% plus one referendum, and it goes the wrong way, and suddenly the whole political class is talking as if there is no way back, and nobody can think of a way back. Tony Blair proposed that we should all reconsider Brexit, and that just got Tony Blair more rude, angry things said about him in the newspapers. He's not well liked today. He was well liked. He's not well liked today. No one in British politics has any effective solution to this preposterous problem where the people have got it wrong by 52%. And no one can see a way back from it. And it may be, perhaps you were suggesting this, that that there is some thinking in the Labour Party that's actually pro-Brexit. And certainly it's interesting fact about the history of socialist politics in the EU, in the UK, that the Labour Party didn't always support EU membership. They wanted a strong Labour majority in a House of Commons that could regulate everything. And they haven't always wanted EU membership. I think most of the Labour MPs, and actually most of the Conservative MPs, are against Brexit, but they're subject to this political axiom today that you have to go ahead with Brexit because of the 52% vote. Remarkable. And of course, that's tied to a lot of MPs knowing that they will lose their seat at the next election if they don't go along with Brexit. Mind you, there are some Lib Dems in seats where they know they will win votes at the next election if they do everything they can to oppose Brexit.
Like Oxford is.
Like Oxford.
Yeah. But I was also wondering as to how much that political sentiment played into the legal argument in terms of the fact that Article 50 is revocable or irrevocable was never a matter of argument. And I find that curious given the fact that, and I wanted to know as to whether it is the political sentiment that it is irrevocable in some sense that led to the Attorney General as in not taking that argument up. Of course, your argument would mean that wouldn't make a difference because it's really not it's not inherently conditional as Lord Reid says. But I was wondering whether as in why that was not taken up, and perhaps we can take that with some other questions.
It's on my list.
There's a question here. Yeah, just 1 second. There's a question here.
My question is that how exactly, I mean, it's really intriguing to foresee how exactly the negotiations are going to happen, because there is a sort of hostility, at least from the side of European Union. And then the people who are going to negotiate on behalf of Britain, they would want a sort of a friendly relationship with European Union. But at the same time, when German Chancellor Angela Merkel says that you cannot really cherry pick, if you want to leave, just leave. So how exactly, I mean, Britain is engaged with European Union, must be engaged, you must be knowing in such deep way, how exactly it is going to be out and still remain in. So
That's a hard one. Okay.
Just
It's on the
one
list.
thing. Two questions. We'll take it at the back in the interest of fairness. Yeah, two questions there. And then we'll take yours and finish off.
Yeah.
I don't know if you can hear me.
Yes.
Yeah. Interestingly, I don't find any reference to the referendum in the legal argument at all. Now, I was wondering whether an executive action followed by a referendum where the people have directly expressed their opinion would continue to be a purely executive action. And secondly, if that be so, the central finding that you highlighted in the majority opinion, that a minister by his decision cannot change the constitutional arrangement, how would that apply? And my last question connected to that is, suppose where the executive draws from the constituent power of the people to alter constitutional arrangements, is it then valid to suggest that the agents of the people must approve that action?
Thank you.
Whether there was any legal requirement for Prime Minister David Cameron for conducting a referendum, whether he could have triggered Article 50 without a referendum.
There's one here.
Yes, sir. So when we talk about Brexit, we're like, I don't know, my mind fails to find enough that we talk about Brexit in the sense that it happens US and what implications it's going to have in, UK, what implications it's going to have in UK and for the Britain in the long run. But my mind fails to gather information on that, what ramifications, implications it's going to have in the long run with the other neighboring states or member states in the EU. Not only in the EU, like being from India, the current relationship with India and the UK, are the power of dialogue and relationships going to be affected at all if on 29 March 2017 if Britain is put to its bed? And one of the most favorite question for me this evening is that, hence being one of the confirmed applicants for UK and for my master's in law, so yeah, yes, exactly. So what is UK, if voted out of from the EU membership, does UK still remains a preferred destination for Indian students or overseas applicants to go and study there?
Thank you. That's an easy one. We'll definitely get to that.
Yeah, so I think that's it, because I think we'll have to finish with your answers. If there's any last question who I've missed, then this is your chance, or to forever hold your peace. Okay, I think that's
okay. Thank you. First of all, why didn't they talk about whether Article 50 is revocable? The litigation, read the decisions, you'll discover that the litigation proceeds on the proposition that it's irrevocable.
That's right.
That bang, if you write a letter to the Council of Europe, 2 years later you're out and nothing can stop it. Well, that's absurd. It's obviously not the case. If only, and I'm not enough of an EU lawyer to know the legal effect of Article 50, but I know this: if you start the process, at any point, you, the member state, and the European Union could sign a new treaty before 2 years is over. There's no question that Article 50 is revocable. They treat it as, why doesn't the Attorney General really go after this? Well, I think two reasons. Number one, nobody wanted the nature of Article 50 to be an issue, because then the judges would have had to refer it to the European Court of Justice, and nobody wanted the European Court of Justice deciding anything that is remotely connected with Brexit for political reasons. And secondly, I think, even though it's absurd to say that it's irrevocable, the majority of the Supreme Court were right to treat it as a step of such constitutional significance that their argument becomes relevant. Now, how will the negotiations happen? Don't they want a friendly relation? Yes, of course they do. The EU has a huge interest in good relations with the UK, and they need to work together. Think for a moment of fisheries. Good grief. How can they have good fisheries policy or pollution, environmental policy in general, without cooperation? And there's an interest in trade, free trade, and there's an interest in good and not stupid policy on the movement of people, even after Brexit. So they need good, friendly relations. And you know what? Britain needs it even more than the EU does. Now, then there's a countervailing problem that the EU wants EU membership to be a good thing, and some of the European politicians have actually been saying Britain has to suffer as a result of Brexit, or what's the point of EU membership? Really interesting dynamic, which will play out in a lot of very complex negotiations over the months to come, starting next Wednesday. And I can't predict how that will all work. Theresa May has said that she's prepared to leave the single market, I don't even understand how it works. There was a potential that you could leave the European Union and not be within the and yet be within a free trade zone. And they will want some sort of trade arrangement that is different from and better than the WTO rules that would kick in if Britain simply fell out of the European Union without a deal. I don't know work out. The European Union won't want to give Britain the free trade it wants if Britain doesn't agree to generous rules for the movement of people from the European Union into the United Kingdom. And migration was one of the drivers behind Brexit. It's going to be a very difficult negotiation, and I don't know how it will turn out. The referendum, you're right, it doesn't play a role in the reasons of the judges. I don't think the advocates for the lawyers for the government tried to say because there was a referendum, Theresa May can use the prerogative. And it wouldn't have worked if they had. It was accepted on all sides that the referendum didn't have any legal effect. There was a statute to provide for the referendum, which said nothing about what would happen if the vote went in favour of Brexit. So the government couldn't really say that either the referendum itself or the statute calling for the providing for the referendum authorized the triggering Article 50. It's very ironic. And does the fact of the referendum count against the Supreme Court majority's decision that a minister cannot trigger this major constitutional change? No, it doesn't. That doesn't undermine the majority decision because there was the referendum itself had no legal effect. Its political effect, as I think some of the judges pointed out, was very important, but they didn't ascribe any legal effect to it. But it's going to be relevant. I'm not finished because the referendum is going to be relevant to my answer to the next question. The next question is a really interesting one. Was there a legal requirement to have a referendum? No. Could David Cameron have triggered Article 50 without a referendum? This is something really interesting thing that gets discussed in the Supreme Court judgment. And the judges actually say, wait a minute, think about it. If the lawyer for the government is right, then any prime minister at any time could have taken Britain out of the European Union in a sort of fit of temper. David Cameron or Gordon Brown or Theresa May could have woken up one morning and think, I'm just so fed up with Europe, and written a letter, or maybe an email. Email would be enough. To the European Council, United Kingdom intends to withdraw. Bang, they send it, and remember the myth that it's irrevocable, and Britain is out of the European Union, and it's totally arbitrary. So now the Supreme Court judges, in Lord Neuberger's reasons, they say we put this problem to the government lawyers. Are you really saying that a prime minister could just take Britain out of the European Union arbitrarily? And the government lawyers say, well, look, the prime minister has a lot of prerogatives, exercises on behalf of Queen Elizabeth II, and Queen Elizabeth doesn't think about it, the prime minister does it. There are a lot of prerogatives like waging war that are quite consequential, and there's no doubt that the prime minister can do that. And Lord Neuberger actually says, well, yeah, but waging war, bombing Baghdad, that's not of major constitutional significance. So that this act of major constitutional significance cannot be an act that a prime minister can exercise. In fact, and here's where the referendum is relevant. The mistake that I think Lord Neuberger makes at that point is that there never was any risk that a Prime Minister with a headache would trigger Article 50. And that's because of the political, legal, and constitutional context in which the British executive works. Prime Ministers are, number one, there because they're the leader of the party that has the majority of the House of Commons. Number two, they're working with a cabinet of senior leaders of their party who want to stay in power. Number three, they're accountable to the House of Commons. And they don't bomb Baghdad without those people behind them. And they don't trigger Article 50 in a fit of pique. So it's very important that the British executive works under tremendous constraints. Theresa May is more sensitively alive to what the people of the country want than Parliament is. And of course, a lot of the talk in the litigation was as if Parliament's the democratic part, and the government, the executive, is undemocratic. In fact, the British executive is highly democratic, and that's why some of the people don't want it making the decision, I think. The final question, what are the ramifications, I'm not sure I understood it, but what are the ramifications for other, say, for British-Indian relations, British-Canadian relations? Will Britain become once more aware of the Commonwealth, which they're not very at the moment? Well, I don't know, and I think that they will still need good relations with the countries of Europe and with the United States, much more than they need good relations with Canada, although that's important to them. And relations with India and China are on a par and will be tremendously important. But I mean, maybe a bit like with the European Union, Theresa May probably wants good trade relations with India more than India wants good trade relations with the United Kingdom. It's more important. India is more important to Britain than Britain is to India, I suppose, in economic terms. Now, so Britain will need good relations with the European Union. One of the benefits of this stupid, if you pardon my expression of my sentiment, Brexit, is that Britain, it will have, it's not completely stupid, Britain will have opportunities to enter into trade relations with other countries that it does not have today. But I'm not the economist and I don't have the crystal ball to tell you how that will work out in practice, except in one respect, which is that Britain will remain the most tremendous destination for graduate students in law. And I say that with complete confidence about the future.
Thanks very much, Timothy. As I think that was a wonderful talk and an interactive Q&A. And I think I second you completely. As a former graduate student in the UK, I think that it will be a hard task to match up to Brexit or no Brexit. So thank you very much, ladies and gentlemen. We've got a small token of our appreciation for Timothy. So once again, will you please join me in thanking Timothy Endicott. Thanks very much. Good night.